off mute. Hi, everybody at home. Got a couple people trickling in. Let's go. Hi, everybody here at the office. My name is Charles. If you haven't met me, I am the managing attorney and owner of JK Closing Attorneys. You may have seen me in Slack answering some of your questions. Feel free to reach out and ask whenever you have questions about anything. And if I don't answer on Slack, sometimes I don't get the Slack notifications. So shoot me a text. And I'll give everybody my phone number here before I go if you don't have it. The one thing that I do ask is please don't share my cell phone number with clients, because most of the time they will just skip right over you and come to me, and I probably have no idea what you've been talking to them about. If you want to get me on the phone with a client, by the way, just call me up. If I answer, I'm available right then and there. We can just three-way them in, or we could set up a time. And I like to do like conference calls with you guys and the client, because my job is to make you guys look good. You're their agent, you're their point of contact, and you're their representative, and I'm part of your team. So, you know, you guys want to be seen as the authority with your clients. And sometimes when you put them in contact with the attorney, they always just want to talk to the attorney about everything. But the reality is, I only know a very small portion of what's going on in your transaction, and I don't want to take that power away from you guys. So just keep that in mind. And everybody does really good with that anyway, but some of you are new. So I want to let everybody know how that goes. You guys are on an excellent team at Premier. Jordana is an excellent broker, and we do a lot of work together. My team is not just me. I have a staff of 25 employees. We have multiple offices throughout South Florida, and we can do closings anywhere in Florida. So any questions that you guys have about that process, I can either answer for you or point you in the right direction. And that's what I try to do. And that's one of the things that Jordana and I talk about a lot, is how can my office best assist your team? So we're not only closing transactions for you, we're trying to give you guys resources to be able to get your clients, whether they're listings or buyer side. You know, it's very competitive out there. So we're here to add value to your team.
I just want to say you're excellent. Your team is excellent too. So
Thanks, Kyle. I appreciate that.
I really mean it, guys. Like,
thank you. Thank you. I appreciate that. I do. We try. You know, I'm never ever going to promise that we'll be perfect, because that's impossible. But I will promise that we'll be there for you. We will answer the phone, and if you guys know me, so if there's an issue or something, you can call me and we'll figure it out. So I know a lot of you have had experience with that, and you know, having to get stuff done, and you know, our job is to perform and close the deal. So some of you too may, if you have real estate experience, especially in Florida, you may not want to work with attorneys because you've had bad experiences with attorneys. We have also had bad experiences with attorneys. So one of the reasons we're a law firm and not a title company is so that we can represent sellers and buyers too. So if another company is doing the closing, we can represent your seller or your buyer, depending on what county you're in. And we help you guys coordinate with the title company to get to closing. And if somebody on the other side screws up, your client or you might have a claim, whether you're going to file a lawsuit or not, you might have a valid claim, and we're there to help you guys enforce yours and your client's rights. And so that is a nice little segue into the listing agreement. Bridget asked me to talk about the listing agreement today, along with some other addendums and everything, because we really haven't gone over the listing agreement a lot. From a legal perspective, you know, Jordana can answer your questions and Courtney can answer your questions from the brokerage standpoint as to what you guys are looking to accomplish in some of your listing agreements. But from the legal standpoint, I'm going to go over kind of what the contract says and, you know, what some of your rights are, because some of you, either whether you're on the listing side or you're on the buyer side, you might have a claim against a seller for not performing. And we're going to go over what that looks like. And then also just some of the things that I see generally on the listing agreement. And Okay, hi, everybody at home. Can everyone at home hear me? I see a couple comments. I just want to make sure everyone can hear me. We good? Okay, thanks, Jordana. All right. So the exclusive brokerage listing agreement, that's the one that I'm going to go over today. There are other types of listing agreements. Some of you have experience with for sale by owners and doing a like an exclusive right to have an open house with them or something like that. I'm not going to go over that today, but just know if you come across that situation, we can help out and put something together like that. Okay. So the exclusive brokerage listing agreement is exclusive because you guys would be the only listing agent if the client signs this. Okay, that's why it's exclusive. You don't want a client who has multiple listing agreements with multiple agents who are all trying to sell the house. So if you have a client that starts asking about that and everything, that is where you guys have to start selling yourselves and why they should use you guys and use Premier as their exclusive listing broker rather than you competing with a million other listing agents. Okay. So the first part, I just highlighted the starting date and the termination date. You do not have to start your listing agreement on the day that you sign the contract. Okay, so today is March 10th. You might meet with somebody today and they might agree to list with you, but they don't want to list the house for 2 weeks because they want to get the house ready or whatever. That's fine. Don't wait the 2 weeks to sign the listing agreement though. Just put March 24th on there and have them sign it today. That way you're under contract with them, but you don't actually start the listing until March 24th. Okay. And then you guys might have the ability to post on Facebook, hey, coming to market soon, blah, 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 all this stuff. You might not have all of your pictures yet because the house is not ready, but you might start generating interest that way for it. Okay. And then the termination date, of course, can be really anything. There are 6-month listing agreements, 9-month, 12 months, depends on what you negotiate with your seller. Now, there are some sellers who they might be turned off by having a longer listing agreement. So you need to be mindful of what the client's actually looking for too. And in reality, you don't want to make it seem like you're going to take a really long time to sell their house, especially in this market. On the flip side, you want to make sure that you have enough time to actually sell the house too. So that is the first part of the contract.
Or can it be?
Yes,
sale?
you need to have a date.
Okay.
You cannot leave it open-ended. Okay, otherwise it's going to be invalid and unenforceable.
But it can't say when the house is sold, it just has to have a date.
No, it can't be forever.
Okay.
There are actually a couple of companies that try to do things like that and nobody has actually gone after them ethically to prevent them from doing that. But I think that even if a contract might be enforceable for that, which I don't think that there's a case that talks about the listing agreement with that. I think that that is unethical from a realtor standpoint. So you don't want to get into situations like that either because you want your clients to be happy and you don't want them giving you bad Google reviews or filing ethical complaints against you. So yeah, plus you want the contract to be finite. You want to know, like, I have until this time to sell this house, and it's good to have that. It's good to have deadlines. People need to meet deadlines. I don't know if any of you are baseball fans, but there's collective bargaining agreement going on right now, and Major League Baseball keeps setting deadlines saying if we don't have a deal done by today, the season's going to be delayed. And if the season's delayed and they lose games, then the players lose money. They're doing that on purpose to generate, a back and forth to actually get the deal done. Similar situation here, like you need to have a deadline to get your stuff in order, right? Question.
So up top, seller's
Yeah.
name and broker. Do we just put like Premier Listings or do we put Kyle/Premier Listings?
So technically you guys as agents have the authority to sign on behalf of the brokerage. But Courtney, do you have an answer to that question? Because I actually don't know what you guys do. Yeah.
My name and /Premier Listings.
Yeah, that's going to be a preference that comes down to your office. It does not hurt to put your name and the brokerage. The brokerage is Premier Listings though. So the contract is between Premier Listings and the client.
Yeah, CJ,
Right.
I would just. it's
Yeah,
sort of-
Jordana, go ahead.
Yeah, I would say just like Courtney Maria said, put your name and the company name. So that way we understand which associate and also the fact that it's with the brokerage as well.
Yeah, there
It
you go,
happens
and
to
that's
me
fine.
that my clients say, what is your name? It's FARBAR, then, so
Mhm.
that's what I just put my name.
Yeah.
Yeah, but you guys can absolutely sign. In the past, I've had agents that have sent me the listing agreements to sign because it says broker/associate, which just like CJ said, you have the authority to sign on behalf of the brokerage to accept the listing.
But the listing is premier listings,
Mhm.
I mean, yeah, not listing.
Broker,
I mean,
broker.
but it is the brokerage's like listing at the end of the day. So even if you were to leave, it'd still be premier listings listing,
Right,
right?
exactly.
Another question,
Kyle.
and I'm asking this because
Yeah,
I
go
know
ahead.
we're gonna run into this. So when it's regarding seller,
Mhm,
if a couple is going through a divorce,
mhm.
right? Husband wants to sell the home, or my mom just died. You know,
Yeah.
I have 5 brothers and sisters.
Mhm.
I want to sell the home. How do we
Okay.
handle it?
Yeah, so I'm gonna go into that right now.
Okay.
So it's really, really important, and I go through this on our contract review too. You need to know who owns the home. Okay, so let's talk about the situation of probate first. You might be talking with John Smith. John Smith wants to list his house, right? Are you just gonna sign this contract with John Smith? No, you need to go to public record and you need to figure out if John Smith actually owns the home before you sign the listing agreement with him. Because if John Smith doesn't own the home and you sign a listing agreement with him, you don't have the right to actually list that property because even though John Smith is saying he has the authority to sell the home, he doesn't. So you don't actually have the authority to list it. So in the situation of John Smith, it might be Kate Smith, his mom, that owns the property. And then you find out that Kate Smith died. Well, did that property go through probate yet? Okay, did she have a ladybird deed so that the property automatically transferred to John Smith upon her death? That's the type of situation where you're looking at the deed that's on public record, and you can either go to PAPA if you're in Palm Beach County, or you go to BCPA and you look at the deed on record there, or you do a Miami property search. I don't even know what they call that one, but there's usually abbreviations for everything. And my recommendation is always to look at the previous deed to figure out who's supposed to be on title. If you just look at the tax record, that could be incorrect or incomplete, because somebody different could be paying taxes for the property than owns the property. Or what happens a lot too is there could be a deed of record on there that only has one owner or some of the owners, and the property appraiser's office they're not looking at that thoroughly to figure out whether or not those are the actual owners of the property. So I've seen situations where like a third of the property was gifted to somebody else, and that's the latest deed that's in there. And just that one person is listed on the tax record. So that's something that you have to look at. You have to look at the previous deed and you have to make sure that you're dealing with the right person. Another scenario might be that there's multiple people, okay, that are on the deed, or a company. Who do you have sign? If it's multiple people and you're not sure, I would have them all sign, because you want to make sure that everybody that is eligible. The question about the divorce, okay, husband and wife are getting divorced. If they are still married, they both need to sign the listing agreement. If they are divorced, we need their marital settlement agreement to figure out who owns that property and what's supposed to happen. Sometimes people go through a divorce and the property is not properly disposed of in divorce. And so I need to look at that agreement, and I might need to send it to my underwriter to figure out, what do you want? Who's going to actually be the person selling this property? Sometimes the marital settlement agreement says the husband gets 100% of the proceeds of the property, but it doesn't also say that the wife has to quit claim deed the property to him. So they're both still on title, they're divorced, but the husband's going to get 100% of the proceeds. We still need the wife to sign everything on there. So we have to look at those and we have to make that determination based on the information they provide. So if you are dealing with a couple that's divorced and you're only dealing with one side, you might have to prepare them to say, hey, once the attorney looks at this, how's your husband or ex-husband or ex-wife going to react when we go to them to say, hey, you need to sign these documents? Are they going to be complicit, or are they going to take you to court because they're done and they don't want to deal with this anymore? So you need to find that out too, because that can make your lives a lot harder.
Same thing, what about if it's like in a trust or like a?
Yeah, if it's in a trust or it's an LLC, first of all, if it's in a trust, we need the trust documents. We have to figure out who the trustees are and whether or not they have the authority to actually sell the property. You know, so those are the types of things where you have to ask the client for the trust. And before you sign the listing agreement, you might have me review the trust and figure out who the trustees are. If we're in a bind and we want to act quickly, we just have everybody sign. Everybody that's listed in the trust as a trustee or a beneficiary, just have them all sign. But sometimes that's not practical, and sometimes you just can't do it like that. If it's an LLC and they have 2 managers or 2 members, have them both sign. Okay, it's very important with a company. If there's one person that you're talking to, it's like they're married. If you're not talking to that other person, you have no idea if the other manager or member of that company even wants to sell the property.
So if it is a trust or if it's an LLC, where the name of the LLC goes at the top as the seller, and
Yes.
each individual signs at the bottom.
If it's an LLC, you're going to put the name of the company. If it's a trust, you might be putting so-and-so as trustees of the blank trust. That's usually how the trust works. If it's an estate and it's in probate, it's probably going to be the estate of Kate Smith. Okay, and then the person signing is going to be whoever the personal representative is, if we know at the time. Sometimes probate hasn't been completed yet, and we have the person who's going to be appointed as the personal representative sign all of the documents, because once the probate is complete, then everything that they signed on behalf of the estate becomes effective. So if it hasn't been probated, we want to get them in touch with the probate attorney, which we work with a great probate attorney named Wendy. Some of you have worked with her before. You know, if we don't know who the probate attorney is, I can't tell you that we can trust that they're going to get the job done. I've dealt with a lot of probate attorneys that don't know what the hell they're doing. So I at least know that Wendy knows what she's doing, and she's personable, and she gets on the phone and answers questions. So that's all I can promise when I refer another attorney to work with as part of the transaction. Does anybody else have any other questions about this section? Okay, it's the most important section. You have to know who you're dealing with. Otherwise, your listing agreement's not going to be valid.
So it's clear, if somebody passes away, probate has to be complete before anyone can sign, in most cases.
In most cases, if somebody died, there needs to be probate. But sometimes you don't need probate, and that's where you can ask me to try to help figure it out.
Yeah.
So, personal property section. As you all know, the personal property section of the contract has a bunch of stuff listed in there. You need to find out from the seller whether or not any of those items are going to be excluded, or if there's going to be items that are going to be included that wouldn't normally be, like furniture. And then I normally recommend just having an attachment with everything laid out. These things are included, these things are excluded. And then when you go to fill out a contract, well, first of all, when you put it on the MLS, you might want to list these things are going to be excluded, or seller wants to include these things. Give me your best offer. And then when the contract comes along, you need to make sure that the contract lines up with your listing agreement, because if it doesn't, your seller could come back after you for breach of contract, because you agreed in the listing agreement that their chandelier was going to be excluded, and in the contract, you didn't exclude the chandelier or something like that. Okay. Occupancy is also really important, figuring out whether the property is tenant occupied or not. So if there are tenants and you're going to sell the property with tenants in it, there's a different procedure than if the property is vacant or if the seller's just living there. Okay. Any questions about either of those? I'm not going to spend a lot of time there. There's no questions. Okay. Price and terms. Okay. Price obviously is super important. So the price that is listed here is not necessarily the price that you are going to list the property for. This is the price that the seller finds acceptable to them. So if you have 500,000 here, but you agree that you're going to list the property for 550, you are gonna write that in the additional terms. Okay, we have the price that's acceptable is 500,000. Seller and broker agree to list the property for 550. Okay, so that's an important distinction, because if you just put 550 there and you list the property for 550 and everybody agrees that you're really comfortable selling it for 500, the seller can then turn around and say, well, actually, I want it more than 500. And this agreement would say 550, and then you can't enforce it against the seller because you didn't put anywhere that it was 500 that they were willing to accept. Okay, so again, if you're listing the property for 550 and the seller's willing to accept 500, you put 500 here, because that's what the terms that are acceptable to the seller.
So I have a question. Majority of us, I would probably say, we always state what the list price is
Mhm.
on the agreement.
Mhm.
So that means that technically, if they accept an offer below the asking price, which is also on the agreement, they could argue the fact that they're not gonna pay our commission because we didn't sell it for the acceptable price, or
No.
how can that?
Once they accept a
negatively impact
contract,
us?
yeah, once they accept a contract, they're accepting it, okay? But what I'm saying is that if they get, because 500 is written here, okay? If you get an offer for 450, okay, the seller could say, I'm not accepting that. And they would not be in breach of contract.
I got you.
If you get an offer that's 525 and all of the other terms you have in here are met, the seller can't say, no, I'm not accepting that. That would be a breach of the listing agreement. Now, you guys might have a million offers, and there's offers that are 525 and 535 and 550, and some of them are financing and some of them are cash. And the seller's saying no to the 525 cash because they want to go with the 550 that has financing. That's not a breach of the listing agreement because they're willing to accept an offer that meets these terms. But if you have one offer that's 525 and the seller says no, they're breaching the listing agreement. And you've brought them a deal that they're willing to accept, and they signed a contract that they say that they're going to accept. Now you're owed a commission. And if they say no, they're in breach of contract. And
So
that's how you
they're
can
still
go
not-
after your commission from them.
So it's like a safety net. Like if you have sellers that
Right.
unrealistically are setting a specific price, but you know it's gonna sell for less, you get them to at least agree
Right.
to a lesser price on the
So
contract.
if you have a situation like that, okay, you're gonna put well, that may not be acceptable to them if you think it's gonna sell for less, right? So if you have a client that is totally unreasonable in their price, that's a conversation that you guys have to have with Jordana about what you want to do too. Because if you really, really don't think it's going to sell for that price, you might be entering into a listing agreement that you have no ability to sell, right? And then that is going to be a grind with that seller to get them to realize once you get offers that you're just nowhere near the price that they want. That being said, in this market, I have had multiple agents ask me this same exact question. Well, the property's only going to appraise for 450. I know they're never going to get 550. They're asking for 550. Boom, they get 575 because this market is nuts. There is absolutely no market right now. You do not know what something is going to sell for. Case in point, there's a house for sale in my neighborhood that is listed for 1.125. Nothing else in my neighborhood has sold for above like 950. And those are like the bigger houses that are in my neighborhood, right? But there's nothing else for sale anywhere near me. So somebody may pay 1.12 for that, and it may not appraise. But I don't know, somebody might enter under contract for that, you know?
If I could be closer to you, I would buy that house.
Right?
But I think it's under contract now.
I know, right? So it's absolutely crazy, but yeah.
So what happens if, the seller like has a counter offer?
Mhm.
Says, no, I'm only willing to accept an offer, like whatever price, and it's actually higher than whatever you put on the.
So if that situation happens, okay, first of all, you try to get them under contract at the price that they want to be at, okay? If you're having trouble selling the property with that seller because they're being unreasonable and they're not following the terms here, that's a conversation that probably you're going to have with Courtney and with Jordana to say, what should we do? Because there is a big difference between, you know, being right legally and going after your client. So you might be correct that your client is breaching the listing agreement, but are you really going to sue them for it and sue them for your commission? And that's going to be a company decision, because you don't want to be on the bad side of clients, and you don't necessarily want a reputation. But at the same time, if somebody's screwing you out of a commission, you're owed that commission. So it's really going to depend on the client. It's going to depend on the property too, and whether or not you think you can actually get to that price based on the offers that you have. And it's going to depend on what you guys are willing to do as a company. And so from a legal standpoint, you might be absolutely correct that they're breaching the contract, but then what do you do about that? And it's similar to when there's a breach of contract just on a sales contract. Somebody might be breaching, but is anyone going to sue each other over it? Maybe not. You know, maybe yes. It depends on what it's worth to you guys. You know, if you've got a property that's $300,000 and the seller is breaching the listing agreement, maybe you just don't want to deal with that seller anymore and you move on. If you have a listing agreement that's for $5 million and the seller is breaching it, maybe you want to sue them. I don't know. It depends. There's going to be a lot that goes into it. Or maybe you want to come to a different agreement with that seller because it's easier to actually accept what they're willing to do rather than suing them, because it's going to cost time, effort, and a lot of money to sue somebody, right? So that's a great question. And there's a big difference between what the contract legally says. Now, what I want you guys to do is to prevent yourselves from getting into a legal battle. And so that's why I'm saying this price that's here is what is acceptable to the seller. But if you're going to list it for a different price, you need to write that in somewhere else, whether it's the additional terms or right next to it. And then if you're writing something in there, have the seller initial it. So this price is acceptable to the seller, but we're going to list starting at $550, initialed by seller. Okay.
But would that be, a change of price addendum, or is that like?
No, just for the listing, because this is the acceptable price that they're willing to sell for.
What I'm asking is, if we, just same scenario, right?
Mhm.
We go in at 500 initially,
Mhm.
and then it's like 2 weeks before I put it on the market. I'm getting ready to put it on the market, and now they want to change the price because they feel like they can probably get a better deal now.
If they want to change the price, the listing price, or the price that's acceptable to them, you need an addendum to this contract. Now, from your guys' perspective, you probably shouldn't change the price that's acceptable to them, and you shouldn't agree to that. If you want to change the list price, okay, fine. You know, but if you're going to list it higher and everybody's agreeing upon that, okay, great. And then create an addendum so that you guys are all on the same page. But if they're saying, oh no, I can only accept 525 now instead of 500, that's not good for you guys, because now it's raising the bar as to what type of offers that your seller's willing to accept. You know, so you shouldn't do that, really. So any other questions about that? Super important part of the contract. Okay. Let me see if there's any chat questions. Okay. Financing terms. Okay. Cash offers, conventional, VA, FHA. If you do not check these off and you get a VA loan offer that meets the price requirement here, and let's say you didn't check off VA, your seller could say, no, I don't want this offer because there's an appraisal contingency or whatever. Now you've cut yourself out of that VA offer, which a VA offer at a high dollar amount might be better than all of the other cash offers that you get. So I am of the opinion that you guys should be able to accept whatever contract makes sense. And so you shouldn't limit yourselves. If you have a client that's saying, no, I don't want to accept any VA or FHA offers, obviously find out why first, but then you need to do a good job on selling them as to, hey, you never know, those might be better offers than the cash offer, because you could get a cash offer at 500, but you could get a VA loan offer at 550. And yeah, there's an appraisal contingency, but maybe that buyer is willing to pay $25,000 above appraised value. You know, some VA loans are really, really good, and some VA buyers have a lot of money. It's just they can get a VA loan, they qualify, right? FHA loans might have more purchasing power than somebody with cash. You might get a 475 cash offer, but a 500 FHA offer. FHA offer might be better. You know, maybe you'll get that person up to 525 because their monthly rate on their mortgage is not going to be that different for $25,000. They're only putting 3% down, whatever it is, right? So I don't like to limit. I don't want you guys to limit yourselves. And if your seller's giving you an issue on that, you just have to do a little bit of salesmanship to try to get them to agree to that. And sometimes VA loans are much better than conventional loans, you know? So.
And what if they have a discriminatory reason? If you don't want to address it because
if they are telling you that they don't want to take it, like for instance, via FHA, they don't want to take it because they just have the assumption that the people are poor or something like that, you have to tell them, you have to explain that to them and say, listen, you can't deny somebody that because they're poor. We can look at all of these and say, hey, we don't want something with an appraisal contingency. But again, that's where you have to sell them on it too and say, sometimes these offers are much better than the conventional loans and the cash offers because they have more purchasing power. And you have to be able to explain that to them because people have misconceptions over that. Okay.
With DA, they have a lot of.
A lot of misconceptions. And it's your job there to educate them too. That's why they're hiring you. You guys are the authority on it, not them. So in a nice way, explain to them how it works. And if you need to get your preferred lender on the phone to explain it to them, utilize your lender and get them on the phone with the person who is selling, because that person's going to buy too, you know, and your lender's going to appreciate that maybe you just got them a buyer. And if your lender's able to explain it to them properly, then they're going to be impressed that your team is impressive, you know, and that's how you're more likely to get the listing too. Okay. I'm not going to go through the rest of the section here. There's seller financing, there's assumption of the mortgage. If you have someone that wants to seller finance, we can talk about that. Okay. Seller expenses. You can put in here that the seller is willing to give a credit towards closing costs for buyers. Okay. If you get an offer that says, hey, we're going to offer 500,000, but we want a credit of 2.5% of the purchase price. If you don't have something written here, you can't hold your seller to that. Okay. So you should talk to the seller about that and say, hey, sometimes they make offers with closing costs. How much are you willing to do? And have that conversation with them and put a number in there. Because there are a lot of offers that come where they ask for concessions for closing costs. Or maybe you're under contract and they ask for, the buyer asks for a concession for closing costs after their inspection is done. If you don't have that in the listing agreement, the seller can say no, the buyer can back out of the deal, and the seller's not in default of the listing agreement because you didn't have anything written in here. Okay. So you definitely need to put something in there. And if somebody's really fighting you on it, you need to know that too. So that when the buyer comes back and asks for concessions, you could say, listen, the seller's not willing to do any concessions. And you'll know that from the start, and you'll be able to set the expectations with the buyer's agent. Okay. Doesn't mean that you still can't convince the seller later on to accept those concessions, but you know, you'd rather have it in there from the start. Section 4, the broker is going to make diligent and continued efforts to sell the property. All of you guys are great agents and you will be diligent and make continued efforts to sell the property. The number one complaint that I get from sellers that call me that say they want to get out of their listing agreement is that they're saying that their realtor is not doing anything to sell the property. And that might be true. It's your obligation to sell the property. And, you know, so if you're not, I don't know what you're doing because you got to make money. So, okay, MLS, you can't list something in the MLS without a listing agreement. So you need the listing agreement to be able to do that. Okay. Does anybody have any questions about the MLS? I'm not the expert on the MLS, but if you have any questions, The one thing I'll say about the MLS is that it is not a contract between the seller and the buyer. Whatever you write in the MLS, it needs to be memorialized in the contract too. Okay, so if you have broker's remarks, if you have the comments we talked about with the personal property, if you write it in the MLS, that doesn't automatically go into the contract. You have to put it in the contract too.
I got one thing in regards to the MLS. Now, I think we talked about this before in the past, but there's a lot of agents that love to put the words seller motivated, right? And, you know, I think I spoke to you before how we have to be very cautious about that, because unless the seller specifically tells you and you have something documented from them, like an email stating that you can list that, it could negatively impact the price and the seller's motives, because you're basically stating that they're willing to be flexible on the price. And we see it all the time. I even made mistakes in the past when I first joined real estate, when I got started, you know, seller motivated without really thinking about how that could have negative aspects.
Yeah, you have to be careful about what you put in the MLS. You have to be careful about saying what types of buyers you're looking for. You shouldn't even get into that. When you are listing a rental, you should not make any assumptions as to what the association will accept. You cannot put things in the MLS like buyer must qualify for or must pass background check. If you put in a listing, buyer must pass background check, you can get cited by the FHA and you can get sued for that. Because they're saying you're discriminating.
Yeah.
Yes.
So
You cannot say that.
They have to have a 750 credit score.
Yeah,
They have to
I
have
know
that.
that.
That's different. Must have 750 credit score is you taking the information from the association and saying association requires 750 credit score. But if you say must pass background check, that's you discriminating against minorities, apparently. Okay, I don't necessarily agree with that, but that's the law. And I've had agents get sued for that before.
Like yesterday, I have a rental and the landlord is actually a lawyer and a judge in New York. When we were interviewing the prospects, he say, well, I actually have another tool where I check you and I found you something. I was like, and he was like, how we find out something he did in New Jersey? So he can do that. I mean, the landlord can do whatever he wants, because he found a lot of things about the tenant.
The landlord can perform their own background check and they could say, you must pass a background check on the application. You guys as agents cannot talk about that. And if you give them the application and it says background check on it and they start asking you, well, what are they looking for? I don't know. This is the application. You fill out the application and the landlord will either accept you or deny you. You can't make any proclamations as to whether or not you think they will get approved, because that could be somebody that's setting you up to sue you. And that happens.
So just to confirm, so if the association does not require a specific credit score, but the landlord says, I only want 700 and above, we then technically can't put that on the listing agreement.
You should not put that on the listing agreement, and you have to tell your seller, listen, you can have your own application for whatever the heck you want, and you can deny somebody, but I have no part of it, and I cannot write that on my listing. So somebody will apply, and they pay the fee to apply, and then the same thing, you can't tell the tenant or the buyer, oh, well, they're looking for this, they're looking for that. You can't tell them that. You just have to say, listen, here's the application. You can fill it out and then you either get approved or denied. I don't have any control over that.
Can I ask a question in regards to capital contribution?
Yeah.
Is that something that just should go in the broker's remark, or is that, would you suggest making?
I think you could put capital contribution in you don't have to just have it in broker's remarks. Yeah, you could, there's a spot for
Actually,
that.
now the
There is a
MLS
spot.
will
Yeah.
tell you if the property has, you have to check.
Yeah,
this.
and you can put it in the regular remarks too, for everybody to see publicly.
There's a field
Yeah.
for it.
It's a
Yeah,
field now.
there is.
Is it necessary to actually have it on this contract?
I don't think you need to have it on the listing agreement now. Courtney.
Oh, I have a question.
Next.
I know a lot of the agents have a lot of questions regarding rentals.
Yeah.
Do you think we can answer, you can answer those with a quick, do you think, or should we make?
Yeah, let's get through this and then we'll talk about rentals before I go over anything else, okay?
Okay.
Yeah. Okay. The other thing about the MLS, it says here you have to put it on the MLS within 1 business day. I have agents who do pocket listings. They have their client sign a listing agreement and then they don't put it on the MLS and they lie to their clients because is the client really going to go look it up on the MLS? Sometimes, sometimes not. There are communities, like for the community my parents live in, for instance, I know that there are 3 agents in there and they all have pocket listings because they're all trying to get both sides of the deal. You cannot do that. So don't do that.
Okay, yeah, one more quick question.
Yeah.
If we sign a listing agreement, let's say for a week from today, do I need the client's permission to put it in coming soon status? Or I can just automatically put it in coming soon status on the MLS today if I wanted to?
If you're gonna do anything like that, I like having it in the additional terms, just to be absolutely clear that everybody's on the same page.
Yeah, because when people start doing drive-bys.
Yeah.
Pissed off.
And the broker authority section does say that you can put it on the internet and that sort of thing, except with the street address, and that deals with Facebook and things like that too. So you're almost never, yeah, because why wouldn't you want to put it on the internet and get permission to do that? You don't ever want to fill out section B here because you want to be able to display it publicly. That's how you're going to get more views. Part E here. Okay, there's a couple of different things here that you can check off. Use the lockbox, withhold verbal offers, and withhold all offers once seller accepts a sales contract. Some sellers don't want you to use a lockbox. Okay, then don't put a lockbox there. Some people have valuables. They don't want any realtor going in. I will tell you a story about a lockbox. I had a listing agent who had a lockbox on the property. He came and he toured a client, okay, in the property. And then all of a sudden, the next day, the seller told him that there was a couch in his garage, okay? They were under contract with the person who toured. Once they went under contract, that buyer took one of his friends back to the property, who's a realtor. They opened up the lockbox, the property was vacant, and they put the couch in the garage. So you have to be careful with the lockboxes. Now, this section, if you are using a lockbox, okay, there's a disclaimer in here that absolves you guys from liability, okay? But that being said, if you have a lockbox on a property, you really should be checking out the property every so often because you don't want your seller to get pissed off at you, okay? And you don't want stuff like that to happen. Withhold verbal offers. I am never a fan of giving a verbal offer to a seller anyway, because it's not a real offer. You have a listing agreement signed with a dollar amount, with the types of loans, with everything that the seller's willing to accept. There's no point in going to him and saying, hey, this agent is offering X amount of dollars. Would you be willing to accept it? Get an offer in writing. So I like having the box withhold verbal offers checked because you don't want your seller to keep asking you, oh, did you get an offer? Blah, 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 all this stuff. You can tell them when I have an offer in writing from somebody, I will give it to you. If you have verbal offers from people, that is like having nothing. You don't have anything in writing. Okay.
So if someone sent you an email with terms, but they just didn't have an opportunity to actually get in front of the computer and send you off, would that be considered verbal,
No,
or is that?
it's not. Well, it's not really considered verbal because it's not verbal, but it's also not an offer because it's not on something. It's not on the contract that you can sign. Yeah, so it's not really an offer either. So you do not have to present that to the client because it's not a real
But
offer.
sometimes agents, like, you're like, okay,
That's negotiating. Yeah, put it together and negotiate with them. Go back and forth until you get to a contract that is actually an offer. Then you can bring the offer to the client. The other thing too, speaking of offers, is in this market, listing agents are getting 1 million offers. You have to present the offers to your client. Okay. So how do you do that? I have agents that are making spreadsheets and they're like, I've got 50 offers. These are all the things, and they're giving their clients access to it. You have to think about how you're going to do that, because you don't want to get into the situation of where you have 5 offers for $500,000 and you picked the best one that you thought was the best one, gave it to the seller, And then 30 days into the contract, the buyer cancels because they didn't get loan approval. And then the seller's like, well, did you get any other offers? Well, yeah, you did get other offers, but you didn't present it to them. That's a problem. That is different from withholding all offers once the seller accepts a contract. Once they're under contract and you get offers, if that box is checked, you don't have to give those other offers to them because they're under contract already, right? That being said, it's also always very smart to have a backup offer and a backup contract, especially in this market, because we're losing a lot of buyers because they're making offers that are unattainable. So if you have this box checked, it gives you a little bit of leeway. You don't have to give the offers to the seller once they're under contract, okay? But you can approach them and say, hey, I have a great backup offer that I'd like to execute a backup contract for in case this one falls through. Your seller will appreciate that, and you will appreciate it if it does fall through, okay?
What do you mean execute a backup offer?
You can have a contract executed with the backup offer addendum. And then if the first contract falls apart, you tell the backup offer, hey, first contract fell apart, we're now effective. And if they haven't moved on, then you're effective with them. And, you know, that being said, if you're on the buyer side and you have a backup contract, okay, you need to make sure you have an inspection period on that. Because if somebody calls you back and says, hey, our contract's now effective and there's no inspection period, you can't just cancel that contract, okay? So if your buyers have been submitting backup offers all over the place, you need to make sure that you have inspection periods on it. And then you also, if they go under contract, you might want to tell the other people, hey, I'm not on backup contract status anymore. We're canceling that. Okay. So you have to be careful with that from the buyer side. If you're ever going to submit an offer without an inspection period, we probably need to have a conversation with the buyer anyway to cover your ass. But you know, that's a conversation that we can have when it happens.
I usually have the buyer send me an email stating that they want to waive that.
Yeah. Always get something in writing from your clients.
What did you get? What did you say?
I have them send me an email stating that they want to waive the right to inspect the property.
Okay.
People ask about FERPTA, especially with Canadian sellers. It says in the listing agreement that they have to comply with FERPTA. So if they are foreign and they go under contract and they discover that they have to withhold 15% and they say, oh, I'm not selling now, I didn't know how to do that. The listing agreement says they have to comply with FERPTA, okay? That being said, before you list a property, if the seller is foreign, we should have a discussion about FERPTA. We should put them in touch with FERPTA Solutions, which is a company of accountants that my company works with and my underwriter works with, to educate the seller as to the process of FERPTA, okay? We can go over FERPTA another time too. Just know if you have a seller that's foreign, let's talk about FERPTA before you list. And that is one situation where we write in the MLS what type of buyer we're looking for. Somebody willing to sign the FERPTA affidavit. Okay. Part G here, it says the seller agrees to make all legally required disclosures, blah, 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 blah. Other than the following, you're not going to write seller disclosure form. I just put that there because I want to make sure that you guys are getting a seller disclosure form from the seller. Not because you have to give it to the buyer, but because you want to have disclosures from the seller, okay? If the seller had a leak in their property 5 years ago and they filed an insurance claim and they don't tell you that, the buyer is probably going to discover that when they apply for insurance right before closing, and then you're going to find out that, oh my God, there is an insurance problem and the whole deal is going to blow up. If you have a seller's disclosure and they don't disclose anything about that leak, you now have protection, first of all, against the buyer, because they're going to say, you didn't disclose it on purpose. You're committing fraud. You're going to say, no, the seller never told me about that. It's not your fault. It's the seller's fault. Okay. So I want listing agents to get seller's disclosures from the seller, but you do not have to give that to the buyer side. It's for your protection. Okay.
They ask.
If the buyer is asking for a seller disclosure form, okay, the terms of the contract do not include a seller's disclosure unless it's added there. So if it's negotiated that the seller is going to provide a seller's disclosure form, okay, then that's negotiated and you guys as listing agents have agreed to it and the seller has agreed to it. Then you can give them the seller's disclosure form. But just know, every time the seller fills out a seller's disclosure form and gives it to anyone, including you, they're putting themselves at risk because they may be filling it out incorrectly or they might be lying. So that's why we don't, from a legal standpoint, really want to give it to the buyer, because we don't want to give the buyer any ability to sue our seller. But that being said, it's not going to hurt for you guys to have it. That's protecting
But
yourselves.
what about when they say that they never live in the property? I don't have.
Right. If they've never lived in the property, they can fill out a disclosure form that says don't know and says they've never lived in the property. And then you have that, and that protects you. And then there's also, we can have a seller disclosure form that we give to the buyer that says the seller's not making any representations because they've never lived in the property.
Can I put in the brokerage remarks, because I have a listing now
Mhm.
and I just put no seller disclosure because.
Absolutely. Yeah. You can say seller's not providing a disclosure. They've never lived in the property. That's fine.
So the seller's disclosure form, you suggest not to put it as one of the documents in the list?
I would not give a seller disclosure form to a buyer.
Because I do see some.
I have people that do that. I see it all the time. I don't know why.
I have to
So
have
the-
it for my file,
Yeah,
to close my file.
Yeah.
Yes, you have to have it for your file to close your file. People say that all the time, but you do not need to give that to a buyer unless it's negotiated per the contract that you're giving it to the buyer. You do not need to. No, it's not part of the
Because I
contract.
always thought I should always have the buyer sign off, so whatever the seller told me, I'm portraying that information to the buyer, so I'm releasing myself from liability.
Mhm.
So if they sign, I'm out of the picture, right?
If the buyer asks you a question that you know the answer to, you give them the answer to that.
Okay.
And if you don't know, you don't know. But all of the information that you're relaying as a listing agent is coming directly from the seller.
Mhm.
Okay, this contract protects you in case the seller lies to you.
Gotcha.
And when you have a seller's disclosure, you have in writing what the seller is disclosing to you. So if they don't disclose something and you don't disclose something and it's not written there, you're safe. They might be lying, but you're safe because you could go back to that seller's disclosure and say, hey, they never told me this. So if it goes to litigation, let's say we close, okay, and the buyer finds out something was concealed, like a leak or mold or something like that, and they really figure out that it's concealed, they're going to go back to you guys and they're going to sue you, they're going to sue Premier, and they're going to sue the seller. And they're going to say, you guys committed fraud and didn't tell me. You're going to be able to go back to the seller's disclosure and say, no, Premier's safe. I was never disclosed this leak. So you go after the seller, I'm out. Bye-bye. Right? And then this agreement is going to protect you in court, and it's going to make the seller indemnify Premier so that you guys don't have to pay anything and Jordana doesn't have to pay anything to a buyer that wins. Okay?
So I had a situation actually with my house, I don't know if you remember, Yanni,
Mhm.
with the seller's disclosure, since I was representing myself as the buyer, and the listing agent gave me the seller's disclosure, and there were a couple of things in the seller's disclosure that were wrong.
Mhm.
For example, it said that there was only one parking space when we actually were assigned two.
Mhm.
But she signed there, so I asked her if we can do an addendum to that. So I was just making sure, that she was
Mhm.
giving me the right information. That and, some things with the pets and all that.
Mhm.
And she gave me these huge things saying that, no, the service disclosures cannot be changed. That is something that, they do that the best knowledge and everything. So I basically just had to sign it because she was like impossible to work with.
Mhm.
So, but what do you do in that?
So you were the buyer.
Yes.
Okay, so you were actually asking the seller to update their disclosure to tell the truth, okay? But you as the buyer, if you're just signing off on the seller's disclosure, you're acknowledging that you've received it.
Yeah.
And if the seller is wrong and it's something that materially affects the value of the property, you could potentially sue them because they lied about it.
So what I did is we basically worked on an addendum
Mhm.
where I was making the changes and basically just putting right next to it my initials
Mhm.
and for them to re-sign it again. And
Yeah.
I was like, if we do it like this, then I'm, okay to sign it.
Right.
But if not, I'm not comfortable with it because I don't know if it's.
Right, and that's fine, but that's you being honest as the buyer. You're not obligated to do that from the
So
buyer's side.
essentially, if you knew that there was a discrepancy, but you signed it on the information that they provided, you could essentially go back after them saying like, actually, this information that I read is not correct and you were wrong and I want to.
Yeah, from a legal, I'm not gonna get into the
Okay,
too far, but from a legal standpoint, if you know something, it's not a great argument in court. Hey, I knew it was like this, but they didn't disclose it, so I'm suing them. You have an inspection period, just back out of the contract. That's what the judge is gonna say, you know, they're not gonna like that
You're
argument.
emailing this to us, right?
Yeah, Bridget has it, so you
I've
got,
shown. so-
yeah.
so-
good luck.
good luck, yeah.
Thank you.
Okay, compensation. I have had agents, bless you, who are getting 4% if they have both sides. And they write here 4%. That is not correct. You need to write 6% here. Okay, I've had agents put 3% here because the other side's getting 3% and they're getting 3%. No, it's 6% total commission. Okay, and then later on in the cooperating broker section, you write your 3%. Okay, or whatever it is.
Can I say something real quick?
Yeah, go ahead.
On that same line, where it says of the purchase, we can add in our transaction.
Yes, if you have a transaction fee, $4.95, you can write it here. Okay, you also can write it in the additional terms, but it should go here. Okay. B is for if there's an option contract. So if you have somebody who's doing a lease and they're giving an option to purchase, you can write a percentage of what it is there. So we have some people that do option contracts. You also get a percentage of the option payment. So if somebody's paying $50,000 to have the option to purchase a property and you write 10% here, you're going to get $5,000 of the option. Okay. And then when they buy it, you're going to get a commission on the purchase. If you have a lease, you're going to write either a percentage or a dollar amount of the lease that you're going to get. And then one of the things that you need to add in here, if you're using this and you're have a lease or a purchase option, you need to write in here that the seller agrees to pay you a commission if the person who leases it purchases it from them eventually. If you don't write that in here, you may not get a commission when that tenant purchases it from the seller. You need to be very clear on that. Okay. So if you are leasing a property, there's a different listing agreement just for leases as well. And it has a section in there for that, and you need to add it in there. But if you're using this contract and you're either going to sell or lease the property, you need to have a contingency in there that protects you. Okay.
Where would you write that in?
Additional terms. Okay, broker's fee is due. 1, if any interest is in the property is transferred with the assistant of the real estate licensee. So if they sell the property and it was with your assistance, they have to pay you a commission. If the seller refuses or fails to sign an offer at the price and terms stated in this agreement, so we were talking about before, $500,000, any type of cash offer or loan offer, and the seller says, no, I'm not signing it. You're owed a commission, says it right there, okay? Or agrees with a buyer to cancel an executed sales contract. Buyer and seller are under contract. Seller decides they don't want to sell anymore, or buyer says, I don't really want to buy this property anymore, and the seller agrees to it. Okay, this would be after the inspection period, maybe after the loan approval period, because the buyer has a contingency. Okay, they can cancel the contract. The seller's not agreeing to cancel the contract with them. The buyer has the right to cancel that contract. Okay, so if you're past contingencies and the seller and the buyer just decide, yeah, we're not going to go through with this anymore, you're owed a commission. Whether you pursue that commission or not is going to be a brokerage and company decision, because you might still have the listing and you might just be going after the next buyer and you may not care. It's a different market right now than it was a couple of years ago. A couple of years ago, when it was very difficult to sell properties, you might really care if the seller did that. Now, when there's 50 offers on every property, you may just say, fine, let's just move on to the next one. It's not worth our time. Who knows? Okay. Part 3, I put 180 days here. Okay. You have a termination date. Let's say it's a 3-month lease. Okay. There is a period of time after, not lease, a 3-month listing. There's a period of time after the termination date whereby if a prospect that you generated purchases the property, you get the commission on that. So if you toured 50 people through that property over 3 months and that nobody bought it, you need to give a list of those people to the seller. And if you have 180 days here, if any one of those people buys the property, you are owed a commission. That's what this says. However, if your listing terminates and they go list with another broker and they sell to one of those previous clients, then no fee is due. And the reasoning behind that is there's no reason why another broker would go and list the property and all of a sudden get it with the same buyer, and you couldn't do that. Okay, so this is protecting you against the seller waiting out the end of the listing agreement and then contracting with somebody you presented to them. Okay.
So when you say contracting, so if we have like an open house, right? So I have all these buyers that come through my open house, and then the next day the seller's like, all right, I'm gonna cancel the contract, or I just want to terminate, this listing. And then like a month later, one of the people who came through the open house
Buys the property. Yep.
This is what's gonna protect me.
That's going to protect you. However, if you have a termination and a cancellation fee here of 500 or whatever it is, and you agree to cancel the contract, okay? If you are going, this doesn't actually talk about what happens. So I think that this is a gray area that could go either way. If you agree to let the seller out of the listing agreement for $500, what I'm doing is giving them a list and saying, I am letting you out of the listing agreement. However, if any of these people buy the property in the next 180 days, I get a commission. That's how you protect yourself there. Okay. Because the reality is you don't want to keep a listing that somebody doesn't want you, because they're going to cause all sorts of problems. It is. You might fight for that. You might try to convince them otherwise, which is fine. But if push comes to shove and they really don't want you listing it anymore, then that's how you would protect yourself. Okay. And you may not have $500 here. You might have a lot more. It depends on the purchase price, Okay, back up here, retained deposits. If the seller collects a deposit from a buyer, because for a buyer that's in default, you guys, if it's blank, get 50% of that. Okay, whether or not you claim that is going to be a company decision again, too. You might have a seller that was put through the ringer by a buyer, and you might feel that it's more equitable to them to keep the $5,000 that they collected instead of you guys collecting the $2,500. I don't know, though. That's going to be a company decision. You want to protect yourselves and make sure that you're entitled to get that if you want it. And if you decide you're not going to go after it, okay, fine. In the sales contract, it says if you guys collect as listing agents a portion of that retained deposit, half of that is supposed to go to the cooperating broker. Okay, so you have to be aware of that. So let's say your seller gets $20,000 in a dispute. Okay, if you have 50% there, you're entitled to $10,000 up to the amount of your commission. So if your commission was only $6,000, you're only going to get $6,000. Okay, if you collect that money and there was a cooperating broker on the other side, they get half of that. Okay, so that's how that works. The cooperating broker section, there are 3 blanks here. You need to fill them in if you are offering a percentage to a cooperating broker on the MLS. And this needs to mirror what is in the MLS. You can't write 3% here and then put 2.5% in the MLS. Because if that buyer's agent gets your listing agreement and it's different, they're going to claim fraud. Okay, people make mistakes, it happens. Okay, but you need to make sure that it mirrors it. If you're going to put 2.5% here, the seller is agreeing with you that you only have to give 2.5% of the 6% commission to the buyer's agent. That's the seller agreeing with you that you're going to get more. Okay, it's really the seller's decision. In this market, there's a lot of people that are not offering a full 3% because it's a seller's market, right? This first blank is for a transaction, or I'm sorry, for a single agent buyer, and the second blank is for a transaction broker. Okay, and then the third blank is for someone who has no brokerage relationship. I see a lot of 3%, 3%, and 0% because you figure if you have no brokerage relationship with a buyer, why are they entitled to a commission? And you have different spots on the MLS to put those percentages in. I have seen somebody make a mistake before where they have a co-listing. Someone else in their own brokerage is co-listing it with them. They're each going to get 1.5%. Okay. They screwed up and thought that the cooperating broker on the MLS was actually their buddy in the brokerage, and they put 3% there, or I think it was 3.5% they put. So they were supposed to get 3.5%. The other side is supposed to get 2.5%. So they put 3.5% in the cooperating broker, and they put 2.5% in the they put 3.5% in the transaction broker, and they put 2.5% in the single agent broker. Okay. The buyer's agent that came in was a transaction broker, and they said, I am entitled to 3.5%. It says it right there in the MLS, and they were correct. Okay. So it goes the opposite way. If you make a mistake on the MLS and offer too much of a commission to the buyer's agent, you're going to be held to that. If you offer too little, if they discover that and find out, you're going to be held liable for that. There's no scenario in which you benefit by putting the wrong amount in the MLS. Okay. So you have to be super careful with that. In no scenario are you putting what your commission is in the MLS. You do not list that in the MLS. Everything that you put in the MLS is for someone else who is viewing your listing. Okay. So just be mindful of that. You guys don't want to give away your money, right? Okay. You also could put flat fees there if you want. I don't see a lot of people doing that, but you could do it. Most of you are going to be acting as transaction brokers. If you are going to act as a single agent, talk with Courtney, talk with Jordana, figure out why, in what scenarios you'd be doing that. Okay. I do have some teams that are only acting as single agents because they feel like that is more beneficial to their clients. I don't know why. I've never really seen any benefit by doing it, to be honest. So, okay. I'm going to skip over these additional terms. Should broker be the only broker involved in the transaction with no cooperating broker or agent? Commission in section 8A shall be reduced to 4%. I see a lot of agents do that. Hey, if I have both sides of the deal, I'll reduce my commission to 4% because you're getting an extra percent than you normally would. And that's fair to your seller. Or maybe you know your seller is a huge pain in the ass and you are absolutely not reducing your commission. Or maybe the property price is lower and you want to get X amount of dollars, whatever it is. You don't have to put this there, but a lot of agents do it to compete for listings. It's just going to depend on the situation. If you're doing that, you put it here though. Okay. You don't write it up in the commission section because there's not a spot for it there. Okay. Like I said before with the leases, if you're going to lease the property and you want to protect yourself in case the buyer sells it and the buyer buys it from the seller in the future, you need to write that here. Okay. Does anybody have any questions about this? Questions about the listing agreement? Home questions? Can't the seller cancel the listing agreement at any time if they put it in writing? No. This section says that it is up to the broker to decide. Broker may conditionally terminate this agreement at seller's request. Okay, so it's conditional. And if you are going to agree, one of the conditions should be that all of those prospects that you brought, if they buy the property, you get a commission for that. And you should stay in touch with those prospects. Hey, just want to let you know, this person canceled the listing agreement. If you go buy from them, you need to let me know because I'm entitled to the commission on that. Just gonna let you know that. And the buyer might say, oh, that's weird, okay. Or more often than not, if something like that happens, the buyer and the seller are trying to conspire to make the price lower so that they don't have to pay you the commission.
Is there like a cancellation form, like an official form that should be filled out?
I don't think so. We can look, but I don't think there is. I've never seen that form before.
So if they.
It's possible.
wrote an email and said, I don't want you to be my brokerage anymore, and the brokerage said, okay, fine. Has to be like a.
You need to create a document. You would need to create a cancellation document. Yeah. And in that document, you should list out all the prospects that you're owed a commission on. Yeah. So, but yeah, we can look for one and see if there is one. You know, I might not have access to it, but you guys might have access to it. I don't know.
CJ,
Yeah.
for the additional terms, so what exactly do you put there? It's interest or refresher?
You could put anything here. Obviously, one of the you know, reducing the percentages, if you're gonna have the lease situation. I've had some people, though, the seller is very clear about certain things, like cannot do a showing on Thursdays, Fridays, and Saturdays. Right at there, you know, that type of stuff.
Or they're not gonna list until a later date, right?
Okay.
Well, if you, yeah, you could put it there if you're not gonna list until a later date, but usually you just change the start date of the listing, you know? So that, I would rather that happen so that it's much clearer, you know, and it's on the first page. Because if you say, you know, we're starting the listing today, and then later on you're saying you're not starting the listing until next week, that's conflicting. Okay. Do people have questions about rentals? What are your rental questions?
There's a lot of, like,
Yeah.
they wanna go over like the rental agreement or the initial offer.
Mhm.
Like a lot of that we need to go over. I'm thinking maybe another class.
Yeah, we can talk about rentals more. The one thing I will say about, yeah, we could do another class on rentals. One thing I'll say about rentals right now is I do not like the contract to lease form. Do not use a contract to lease. If the landlord is requiring a contract to lease, then let's make sure it's filled out properly first before submitting it. Because the deposit that is on a contract to lease will become a hard deposit if the tenant decides not to lease. So if they put $1,500 in deposit and then they say, I don't want this anymore, I'm not signing the lease. The contract to lease says that $1,500 goes to the landlord.
Right. So if
That's
you-
what the contract to lease says.
If you represent the landlord, you want that. I want that.
If you represent the landlord, you want it.
Yeah, that's what I want.
You know what I mean? That's okay.
No, because you know, right now, people is putting multiple offers, so
Yep.
if you have, you know, and then. you
Yeah.
know, what is
Well, they
my
have one
plan?
deposit, and then they have multiple offers, and then they breach the contract to lease. The one thing I'll say about that is you might be buying yourself a headache doing that. But it's protecting your landlord.
Yeah, I think we should definitely do a class on the rentals.
Yeah, we can do
I
that.
think we're all getting a lot more rentals.
Okay. I'm gonna quickly cover some of the addendums too, just so you guys are aware of some of the things that I'm seeing, and I educate you on these too. This is what the form appraisal contingency looks like. And I am preferring you not to use this appraisal contingency. If you want to put an appraisal contingency in a contract, I would rather you use our preferred language, which is this, okay? There's a lot of appraisal contingencies being added to contracts now because properties aren't appraising. People are offering above asking price. And if you are on the buyer side, it's becoming harder to get your offer accepted with just a straight blanket appraisal contingency. You might be needing to say that you're going to pay X amount of dollars above the appraised value, okay? If your buyer is going to pay above appraised value, I do not want to see the language that says buyer is willing to pay $10,000 above appraised value. That means nothing and it leads to disputes. Had a dispute over it yesterday. Okay, it is the quintessential language that leads to a dispute because it doesn't say what the seller is willing to do. It doesn't say that you are going to change the purchase price. It doesn't say you're going to reduce the purchase price. Okay, this first line here says buyer and seller agree that should the property appraise for less than the purchase price and greater than blank, the purchase price shall not change due to the appraisal. Okay, so if the purchase price is $500,000 and you write 490 here, and it appraises for anything above 490, the purchase price is not changing. That's $10,000 above the appraised value. It's the same way of saying it. It's a better way of saying it. Okay. The next line here is for if you are going to reduce the purchase price. It doesn't happen that often. So a lot of times we just end up deleting this paragraph and not using it. Okay, so you can imagine a scenario where the purchase price is $550,000, the buyer's willing to pay $10,000 above, but everybody knows it's not going to appraise for more than like 510 or 520,000. The seller even knows that, and they're willing to say, yeah, we'll take less than 550, but we're all trying to get that appraisal as high as possible. That's what this paragraph is for. Okay, so if it appraises at 530, the purchase price is going to be reduced to 540. Okay. If you have something like that, we need to talk about it before just using the language and figuring it out. We just got to confirm as to what's going on. Okay. The last paragraph here is the actual appraisal contingency, whereby the contract can cancel if it appraises too low. You need this. Okay. You need usually this, and you need the first line. Okay. To protect your buyer and to protect your seller. Okay. If the property appraises for less than $500,000, the party shall renegotiate the purchase price. That is great language on the buyer side, because you are not obligated to buy the property if it appraises for less than a certain dollar amount. Should the parties be unable to reach an agreement within 3 days of receiving the appraisal, either party may terminate the agreement. That is nice language for the seller, because now the seller feels empowered that they don't have to sell the property if it appraises too low. I have seen people look at this addendum, the regular one with $500,000 there, and not want to accept an offer. And they will look at this language, which merely adds that the seller can also terminate the contract with $500,000 there. And they're like, okay, yeah. And it's just a psychological thing from the seller's standpoint of where they're like, okay, I can agree to that, because they feel like they have options, right? And there's no harm using this, and there's no harm using that. So I don't like using the other appraisal contingency. But that's what I'm here for, though, too. If you need to figure out an appraisal contingency language, contact me and we'll figure it out, and we'll put the additional terms in there. The post-closing occupancy. There's a lot of post-ocs happening right now because sellers don't know if they're going to be able to find a place, and buyers are like, we'll give them a post-occupancy so we can get under contract. I don't like using this addendum. The reason is it says the contract is contingent upon the buyer and seller within 10 days prior to closing, delivering to each other a mutually acceptable written lease. If it's contingent on that, and they don't agree to the terms of the post occupancy, you could lose the transaction, because either side will say, I'm not closing. The deal is contingent on this. So I don't want to use this, because I don't want to give the buyer or the seller an out because they can't agree on the terms of a post occupancy agreement. Okay, so I don't want to use this. If you do use it, you also need to add in an escrow amount, especially if you have the buyer. There's no spot on here to add escrow. So you have a rental amount and you have a post-occupancy date after closing, but you don't have other terms that would be necessary for a post-occupancy agreement, like an escrow. I've had sellers argue, I didn't agree to an escrow on here, and they didn't. This is preferred language that I like adding into additional terms. The buyer and seller agree to execute a post-occupancy agreement with the following terms. It doesn't say the deal is contingent on it. It says they agree they're going to execute one, okay? It has a termination date, it has the rent amount, it has a security deposit, and it has a penalty for staying past the termination date. Because if the seller doesn't leave, what's their penalty? So from the buyer side, you want to think about all these things. From the seller side, less is more. You don't want a penalty. You don't want an escrow. You don't want to pay rent. You know, so you could put 0 on all of these things if you want. It's a seller's market. It's all negotiable. But these terms are not on the post occupancy addendum. Okay. And then I also write all other terms. You okay? We almost lost Roni. All other terms of the post occupancy agreement to be agreed upon prior to closing. Okay, so when we write a post occupancy agreement, it has terms about insurance in there. We have a standard form. Sometimes we get into arguments with the other side about them, and then we decide what we're going to keep in and what we're going to take out. But these are the key terms here. You'll get the deal done if you at least have these. Okay. Sale of buyer's property addendum. I have a lot of buyers who need to sell their home in order to buy a house. If they don't have this addendum, they're taking a big risk. Okay. I have a scenario where I'm on the seller side right now, and the purchase price is $1.3 million. And the buyers said at the end of their loan approval period, we're canceling the contract. We don't have loan approval. Their lender screwed up and gave me way too much information. And then their attorney kind of screwed up and gave me way too much information. Originally, they said they were canceling the contract because it didn't appraise. Well, I looked at everything and found out that they were only getting a loan that was 70% loan to value. Their appraisal was pretty close to the purchase price. I'm like, how was this a condition of their loan approval? Well, I got their conditional loan approval and it wasn't a condition on there. So they were lying about that. So I said that they weren't using good faith and diligent effort in applying for the loan. I also saw on there that their loan was contingent on the sale of their property. It said that they needed to get $800,000+ from the sale of their home. That was never disclosed to the seller, and they never had this addendum. If they had this addendum, they would have been able to get loan approval, because under the new contract, it says if you have to sell your house in order to satisfy the terms of loan approval and you have this addendum, you can get loan approval under the new contract. They didn't have that addendum, which actually would have been bad for the seller in this scenario. But the other thing that they did was their sale of their property was not until after the loan approval period on our sale. So I'm arguing that they had no ability to ever get loan approval under this contract, and so that they're in default because they used bad faith. They tricked the seller into signing a contract by saying they could get loan approval within, I think it was 21 days. And I found out from their loan approval that they had 0 opportunity under the contract to do it. So I'm arguing, I think they have 40,000 in deposit. I'm arguing, and I don't normally argue for deposits a lot, you know, because if someone cancels during the loan approval period, you guys hear it from me in our contract reviews. You don't have to give the seller any information. You just say, oh, we don't have loan approval, we're canceling. And they say, give me your loan approval with conditions. Give me this, give me that. And if you're smart on the buyer side, you don't give them anything. I started asking questions. I started getting answers. And every answer I got put the buyer more and more into default in my mind. So I'm going to be arguing for that deposit. So you guys need to be very, very careful from the buyer side as to what information you and your lender are giving to the seller. And again, if your buyer has to sell their property, you really need to have this addendum. And if you don't, we probably need to have a conversation, and then you need to get something in writing from your buyer saying that they're comfortable not having this addendum, because you guys could be in jeopardy if you just don't let them have this addendum. I have another one that's just like that. The buyer is in default and they're blaming their realtor for not having them sign this addendum. They always blame you guys for everything. Okay. So even if you had a million conversations about it and you all agreed that it would make a better offer if you didn't have this addendum, if you don't have that in writing from your buyer telling you to do that, they're going to say that you screwed them out of their deposit. So you need to cover your ass on things like this. Okay.
Should we put the closing date in there?
Yes. So if the offer that you are submitting is closing on April 30th, You want to put April 30th here because you want as long as possible for them to be able to sell that house because you don't have any control over when that house is going to sell. Okay.
Can I do an additional addendum for that? Because right now I'm under contract and this buyer needs to sell her house,
Mm-hmm,
but she lives in Kentucky.
mm-hmm.
And under contract says 30 to 45 days to.
Yeah, they can
to
change.
close.
Yeah.
So.
Are you during your loan approval period?
Yes.
I would use the fact that you're within your loan approval period to try to get this signed and say, listen.
No, I already have that signed.
Oh, okay.
I just wanted to see like.
So whatever the date is there, when you come upon that date, if the property's not sold yet, you need to extend this, okay? So if your buyer, if the sale gets, ooh, what did I just do? Screen sharing stopped. I don't know what happened. Where'd it go? Okay, hang on.
Share screen down at the bottom.
Yeah, but I don't have the screen that I need to share.
You need a document post?
Yeah, hang on, I'll find it. It did. Sorry, guys, I'll get it back up.
You have a button that it like duplicates the desktop and it opens another desktop. That happens to me all the time. Where did everything go? It's on the other desktop.
Yeah, Microsoft Edge unexpectedly closed. Okay, we're back. So what I was saying is if their sale gets extended, you must extend the time frame of this addendum, okay? So if it says here that the property must sell by April 30th and they extend their closing date, okay? And you don't change this and amend it to the new closing date, you're losing this waiver. So you need to extend it if their property hasn't sold by this date, or you need to cancel the contract. So if the seller says, no, we're not extending, you say, okay, fine, we're canceling. You have to protect your buyer, otherwise they could lose their deposit. You always have to remember when you're on the seller side, you have no control over whether or not the buyer can close, okay? That's one of the reasons why we do seller reps in Broward and Miami. You know, we can help negotiate with the buyer, but we don't have control. There's a veil between the seller, the title company, and the buyer and the lender. When we're in Palm Beach County and we're the closing agent, we have direct communication with the lender all the time. We know a lot more information from the lender than if we're in Broward or Miami, because they're not on our team, right?
Is it okay to put in the listing that, like, say you're selling a property in Broward?
Mm-hmm.
If I put in the listing that I want that the seller to use JK clothing?
Okay. So as a listing agent, you cannot force the buyer to use your preferred lender or preferred title company or law firm in our case. However, when you are negotiating, you could say your offer would look a lot better if you used my team, and you're in a market right now that's a seller's market where buyers are going to be more amenable to doing that. Okay. And that is always a great thing, not just because I get paid more money on title files. I mean, believe me, I would love to have every file be a title file, but in this market, we are losing so many buyers because we find out that they had no chance of closing the loan. And if you don't know who that lender is, that offer really is not as good as if they use a lender that you know, because you know that they're going to qualify the buyer. And they're also going to tell you this person has no shot, you know? Same thing, whereas if you get an offer that has a pre-approval letter from Bank of America, you know right away that that offer is nowhere near as good as any offer from any other lender. You just know, right? And it's true. That's you know, that's the reality.
Why is that?
Bank of America, I mean, is big institutional lenders tend to not work as well as other lenders, but Bank of America in particular is just very, very bad. I can't explain necessarily why, other than they're so huge that they don't necessarily care about every individual file. They just don't. There are some loan originators for Bank of America that are good that I've worked with, but they're few and far in between. And almost every single, Quicken, Rocket, all of these companies, I've had nightmares with them before, but the lenders that you guys work with, I don't have that many nightmares, because similar to us, we get on the phone when you have an issue. Your lender gets on the phone with you when you have an issue, and they protect your buyer because they care about the relationship with you. Okay, we care about our relationship with you. We care about the client, and you guys care about the client, but we're interested in making sure that you guys are protected and you guys are succeeding and you guys do well. And that's why you have relationships with lenders, and that's and with title companies, that's how you explain how your team works to a buyer too. If you have a buyer and they're like, oh, I got a great rate with my Bank of America. Hold up, please talk to my trusted lender. You don't have to use them, but please at least talk to them. And I will tell you that Bank of America is not that great. I've dealt with them before. They may seem great and you may have banked with them for 30 years, but that person, your branch manager at Bank of America that you've known for 30 years is not the same person who's going to be working on your loan.
That's the problem. They think that.
Absolutely, they think that. And then some of these places that do the bait and switch, they do a very low interest rate, but that's based on unreasonable conditions that the buyer can't meet, but they don't tell them that, that happens all the time. So you guys can't force your clients to use people, but you can tell them the pitfalls of using whoever they're thinking about using, and you can ask them to at least speak to somebody that you trust to be more well-informed. And you can never tell them you have to use them. You just can't.
I would say take a second opinion.
Absolutely. Okay. That's all that we're gonna go over for now. We're gonna go to happy hour at Mizo House. Are there any questions at home? My battery is running low. I set it up like that so we can go to happy hour.
No questions, bye.
Tati is here. We're going to Mizo House, right? Yeah. So if you guys want to start heading over there, we've got it set up and we'll meet with everybody. Yeah, there's a parking lot there. Hi and bye everybody at home. If there are any questions, reach out in Slack. Ask any questions that you have. If you're gonna come meet us at Mizo House, come meet us. But thank you everybody, and we'll be in touch and we'll do this again.
No, I was